Call Jane at 1-800-510-JANE.
Is it pertinent or prejudicial for a jury to know about an accused's criminal past? That's what we're talking about tonight with our guests Wendy Carroll and lawyers Tim Danson and Karen McArthur. Let's talk to Jackie, who's calling from Bowmanville. Hi, Jackie.
Hi, how are you?
Good, thanks. What do you think? Should the juries get to know everything?
I absolutely think they should know everything. Just to start off with the defense lawyer, with all due respect, she earlier made a statement to that victim standing or sitting beside her that we shouldn't personalize this. It is so hard to say that to a victim who may have suffered serious consequences or serious effects from a crime. You cannot ever think that you can't personalize this. I know from her perspective she can't, but this should always be about the victim, and don't ever forget the victim, because we're talking some heinous crimes can affect victims on a lifetime basis. It's not a matter of one case is done, move on to the next for these victims. So it should be absolutely introduced, and let's not forget also the juries and judges are adults. They are mature adults. You can't let them decide on something so serious and not tell them all the elements of the offense that's involved here. And one of those.
Okay, let's talk about that issue, because that's a good one. I mean, aren't juries mature enough? Aren't they smart enough to have all the information and know that what they can consider and what they can't?
Well, we've recently decided, Parliament's decided that they're not mature enough or wise enough to hear everything, for example, about a sexual complainant's past. I mean, there are things that are held back. It's the flip side of the same coin. There are things that are held back so that you focus on the real issues. And with respect, Jackie, what I meant when I said I didn't want to personalize the situation was Wendy had said, I hope nothing bad happens to you. And I said, let's just focus on the debate. Right. I do feel sorry for what happened to Wendy. But in terms of, there are lots of things that are withheld from juries because they are irrelevant, prejudicial, will exacerbate the trial, will prolong the trial, make it costly, and divert the jury's attention away from the real issue, guilt or innocence.
But you know, the point that you raised, to me, takes it that it's all you're doing is raising another example of where the victim is re-victimized, because you're talking about the victim in a rape trial having her history brought up. And that does happen, and it happens frequently in these cases.
In exceptional circumstance, not frequently anymore.
Well, I don't know. If you talk to the number of women who've gone through it, it seems to happen a lot more frequently than it's supposed to. And both of those are the re-victimizing the victim, aren't they? Where they don't get to, the jury doesn't get to hear about past criminal, and they re-victimize the victim.
There are strict statutory limitations on when a jury can hear about the sexual past, and they can only hear about it for principled reasons that are advanced and argued before the judge, opposed by Crown Counsel, and then they only hear about it if the defense counsel wins. So there are strict limitations on it. I don't think that goes to the maturity
of juries, does it? About whether there or not that they get to hear that particular information.
I think it does. I think not the maturity, but sort of the legal wisdom, if you will. The jurors are there to balance the facts, to come to the determination on the facts, and you give them the facts that are critical to the issues in dispute. You don't give them all of the other stuff, because it's not necessary to determine the issue.
We're giving this jury a huge decision to make,
right.
Yet we're not giving them all the pertinent information. If we've deemed that they're not capable of that, then maybe we need to look at another system. But right now we're going halfway in my eyes.
It may be helpful for context. The Corbett decision that gives rise to this whole legal issue is that in that case, the reason why the Supreme Court of Canada allowed the murder conviction to go before the jury and be informed is because the defense lawyer was cross-examining the credibility of many Crown witnesses who had lengthy criminal records. And the Supreme Court of Canada was concerned that the impression to the jury was, if they didn't get to hear the accused's criminal record, was that only the Crown witnesses had criminal records and were of bad character, and the accused was squeaky clean. And so the court was concerned about the balance. So ironically, even though Corbett's the decision that gives rise to this issue, in that case, the court felt that you can't, on the other hand, mislead the jury and give the jury a wrong impression, and therefore allowed it in. So, I mean, personally, I think on a day-to-day level, judges do a very good job in balancing the prejudicial effect and the probative value. It's really what happens is after they make the ruling, like in Wendy's case, that you can't let the jury know this, that then the accused says, I feel kind of safe about this now. Now I'm going to bring my character into issue, and I'm going to raise issues that make it very unfair.
Make it look like I'm a good guy.
Tim mentioned this twice, Jane, and I'm quite surprised that after, I think it was Mr. Keogh said, I'm such a great family man, that the Crown wasn't in turn able to go after him and put before the jury his prior convictions.
But the judge didn't let him.
He didn't let him in that case. Normally, you put your character into issue. everything comes out. It's fair game, everything comes out.
That was the impression I was under. And then this happened
and it didn't
numerous
happen.
times.
And you have to sit there and listen to it.
Yes.
It must have been horrendous.
The jury arrived at the right result here.
They did, but my whole point is that I think I was lucky in that fact.
Or perhaps,
and I don't think that's...
perhaps the balancing does work.
Let's talk to Prima, who's calling from Windsor. Hi, Prima.
Hi.
Hi.
I think the real issue here is the risk to reoffend. That is the main issue. Clearly, rehabilitation has failed in some cases, not all. And monitoring is the key. I mean, we're talking, maybe we need more parole officers to enforce monitoring. I mean, the problem is we're talking about money here, which makes a lot of people nervous. This is only, a cosmetic solution, but more monitoring. For Canadians, for women in Canada, this is just as important an issue, violent crimes against women, as APEC is to the rest of Canada. And I don't see why we cannot have an inquiry or a government roundtable which can go across the country and garner responses and attitudes towards people about what they really want. Again, I know this is expensive, but we need to put more money towards monitoring and more money towards manpower. Secondly, I personally believe that because of this risk to reoffended, we can no longer be idealistic about the criminal justice system and about survivors. And along that vein, I want to thank Ms. Carroll very much. I think she's shown a great deal of courage coming on the show today and during the trial, and it's very reassuring to women who have gone through the same or similar experiences that we have someone to look up upon. And I guess the other issue that I wanted to say is two things very briefly. Regarding the sexual complainant issue, I think that's inappropriate in this context. We're talking about harm done. We're talking about violent sex assaults. We're talking where the complainant is not causing violent harm.
Yeah, but we're also talking about juries getting information.
Exactly. We're not. The only penalty there is that the alleged perp can go away for it, and that's what defense attorneys are for. Let's not underestimate, and I know it's been said before, but let's not underestimate.
That's the only reason you're here. Prima, thanks very much for calling. We've got to move on. Let's talk to George, who's calling from Saskatchewan. Hi, George.
Hello.
Hi. What do you think? Should juries get to have all the information or not?
Well, in my opinion, and I agree with your guest there, and I congratulate her for being a victim and coming forward and being on your show. That takes a heck of a lot of courage. I think the whole entire judicial system should be changed because they say there's such a thing as a criminal justice system. There's no such thing. There's only law. When it comes to trial, that's all the judge looks at is law, and they could care less about the victims.
Well, what do you want a judge to look at if he's not going to look at law?
Well, they're always looking at a point of law. They're not looking at the overall picture about the victims. They want all the information on the victims, but you can't get the information about the accused past, being on probation or what have you. But they want everything on the witnesses, and they want everything about the victims. And I think the system is in bad state of repairs right now and needs to be changed.
Okay, thanks very much for calling. I don't agree with you, George, but I know that he does reflect the way a lot of people feel. They feel that the system is busted and that it's not working anymore. It's not working for anybody.
Well, I think if you look at statistics, too, I think we have something like 80% of our people going back to jail have been there once before. That's an 80% failure rate. Why is that not public knowledge? Why? The fact that there's a person killed once a month in this country by someone on parole, is that an acceptable statistic to you? I had no idea, and everyone I speak to has no idea either. So I don't think that's really acceptable to the public.
And so you're going to, take this fight to the end with this civil suit, or will the civil suit be allowed to go forward?
Absolutely. It will proceed. Now that the criminal trial is over, we go to examinations for discovery. We'll be examining the federal government officials in detail, and it'll run its course.
Okay,
if
great.
they'll answer your questions.
If they
it's always
answer.
A problem.
Thank you for joining us, and
Thank
congratulations.
You. Thank you
I
very
hope
much.
your healing continues. Thank you. Wendy Carroll is suing the federal government after she was attacked by convicted murderers who were freed by the parole system. Tim Danson is her lawyer. Karen McArthur is a criminal defense attorney. I'll be right back.